In Georgia, almost all domestic relations cases, family law cases, are sent to mediation prior to any final trial. In some counties, they even require all cases go to mediation before even a temporary hearing. Mediation is an awesome opportunity to try to settle your case without having to have a judge tell you what to do with your life. During a mediation, a mediator will be appointed to help you come to a resolution. The mediator can't make a decision for you. A mediator can't even force you to come to an agreement, but they can help you work through the issues of your divorce or custody issue in order to come out with a resolution that will be satisfactory for both you and the opposing party. I work as a mediator in a wide variety of cases, and I love this because it lets people really think about what is best for their child or for them or for their work situation and craft a plan that works for them. So for example, in a parenting plan, a standard parenting plan might be that the non-custodial parent has every other weekend. But if they work in the restaurant industry and so have to work on the weekends, that might not be the best time for them to see their child. And so the parties may want to work out a different agreement where maybe if the child is young and they don't need to go to school, that the non-custodial parent has Mondays and Tuesdays because those are their days off. You may also want a parenting plan that shifts as a child gets older. For example, younger children do better with more frequent contact with both parents. And so you might want a schedule where the non-custodial parent sees the kid every 2 days or every 3 days, something like that. Whereas older kids, if they have activities after school or they just want a routine with going to school, or if one parent's house is closer to the school than the other, you may want a schedule that allows them to have fewer transitions during the week. So you may want to say that once they start kindergarten, the schedule is going to change. So you can do a lot of things like that that a judge is just not going to hear if you go to trial. On financial issues, the courts kind of default to looking at what is marital and, what is your income, what is his income, her income, and then kind of divide things 50-50. If you want something different than that, you have to make the argument and overcome kind of that presumption that a lot of judges might have. And so if you want to do something interesting, like keep the rental properties you own and continue to split the income that comes out of that, you're really going to have to work that out in a negotiation or mediation, because generally the courts are going to either award one property to you and one property to your spouse, or is just going to force a sale of both properties and split the income from that. There's not going to be a lot of this like post-divorce sharing of things. And so it may strongly benefit you to go to a mediation. A thing to remember about mediation is just because you show up doesn't mean you have to agree to something. So if you show up and you try in good faith to come to an agreement and you're just not able to do so, that's okay. You do not have to agree to anything. If you're ordered to go to mediation simply by showing up in good faith to try to come to an agreement, that is all that's required. When you get to mediation, the mediator will lay out their ground rules. Those ground rules are generally that anything that happens at mediation stays at mediation. That means that no party can leave the mediation and say, well, you said at mediation that you would do this, why won't you do that now? You also can't say to the judge, well, they were willing to agree to that at mediation, so that's what you should do now. The mediator may also choose to, at some point, put you and the other party in separate rooms. And what that is called a caucus. In a caucus, it'll just be you and the mediator, and if you have an attorney, your attorney as well. And that will allow the mediator to kind of understand your side of the story and what you really want, and maybe what your negotiating position is before they go and talk separately to the other party. And anything that happens in the caucus is also private. The mediator can't go and share it with the other side unless you give them the opportunity to do so. And we do recommend that, as much as you can allow the mediator to share with the other side, the better, because the more information that's out there, the better that the negotiation will go back and forth. At the end of a mediation, you're going to write up either a mediated agreement, which just says what you agreed to at mediation, or you can write up the whole settlement agreement, especially if the mediator has experience writing up full settlement agreements and parenting plans. They may want to just help you draft that document right there. And so everybody can sign it and you can submit it to the court, and the court will sign off on your agreement as the final order. You can also choose at mediation to do a full final settlement agreement. But if you're not going to get that far, the mediator may encourage you to do a temporary agreement, something that might just last during the pendency of the case. They may help you come up with a partial agreement that maybe you can decide on the child support issues, but you have some disagreements still over the parenting plan. You can agree on part of the plan on a final basis and leave other issues for the judge to settle. And that just narrows the issues so that your trial at the end doesn't have to be as long. Your attorney doesn't have to spend as much time on discovery, on preparing for trial, and can just work on narrowing the issues. Even if you go to mediation and you don't settle everything all at once, that's okay. If you can just narrow the issues, even that has been a successful mediation. And even if you come to no agreement at all, usually a mediation will allow both sides to understand the other side's position better, so that you can understand if your case is going to be successful, if what you're asking for is reasonable. The mediator can kind of help pull things out of the other side so that you can understand why they're asking for certain things, if they're negotiable on certain things, if not. And so even if you don't come to an agreement, a lot of times mediation is still very much worth going to.